Welcome back. Just before the break, we were talking about different legal aspects of if you have a property in Dhaka or Bangladesh, and if there is any problem with that. And our guest today, Nabila Rafique, was advising us how to go about it. Yes, Nabila. We had asked you about this, and then we lost the thread because there was a break. I asked you how efficient or effective can these high commissioner people be? I mean, we have problems. We have land in there we have inherited, and then when we go there, there are other claimants, and then they produce this document, that document, and I'm there for a month, and then by the time everything is sorted out, it's time to come home, and then next year.
Yes, so I mean, you have to understand that this is something you need to do simultaneous to the legal action. The High Commission will not be taking the legal action for you.
True.
So they act as a very high-level post box. They communicate the concern to the respective authorities, and they, because of their status, this is the High Commission, they end up getting a response. For instance, in the cases
from whom? I mean, they write to whom?
They would write to the respective parties, such as the AC Land or the DC office, the area chairman, sometimes the police in charge of that particular area,
Right.
and then they would make a response back to the High Commission. So, for example, in one instance, an example that I give, one of our clients, when we encourage them to communicate this concern to the High Commission, and then the ACLN reported back to the High Commission that the chairman has taken an interest to mediate the dispute between our client and his neighbors. So it is not very essential, but it is there. So you asked me, are there any? That's what I'm just saying, that there is.
Somewhere there, I see that you wanted to use your skills of IT to contribute to LCIA's research operational activities. What is LCIA?
It's London Court of International Arbitration, and it's quite renowned. It is a very premier body for arbitrations, and dispute resolution being one of my area, I had some interest in it. So that is there.
So this dispute resolution, I mean, it can be about land, it can be about property, it can be about business contracts, it can be about
yes, arbitration,
nationality problems.
Yes, arbitration is the, I would say, in vogue of dispute resolution, because litigation, be it in UK, be it in Bangladesh, litigation is always very time and yes, it takes time consuming, it's money consuming. Arbitration is more informal. You don't need to really have rights of audience to be formally an advocate or a solicitor or a barrister. Generally you are, but you don't have to be in order to bring arbitration proceedings. And it really helps business. For example, my UK law practice, the clients that we service, the business clients that we service, arbitration is always something we encourage from a very outset. And it saves time and it saves money, so why not? And it is, as I say, the go-to dispute resolution system at the moment.
Since you also practice in Bangladesh and also are interested in problems arising in Bangladesh regarding whatever litigation, I understand, I may be wrong, there are hundreds and thousands of cases are pending in courts of different level, maybe district court, maybe magistrates court, maybe high court, maybe, I'm not sure about this, the Supreme Court, but hundreds and thousands.
So there are, the Bangladeshi judiciary is very similar to the UK. So there is the court, and then there are lots of tribunals and ombudsmen. And the lower court in Bangladesh is called the district court. And the magistrate court, and then there's two levels of high court: the high court division, the high court appellate division. Sorry, the Supreme Court has two divisions: Supreme Court High Court division and Supreme Court appellate division. And you have to have rights of audience separately in each of them. So for example, myself, I am Supreme Court High Court Division enrolled, whereas a much senior lawyer would be also enrolled in the Supreme Court. So there is a big backlog. In UK, there has been a very conscious effort to minimize that backlog. I think back in 20 years back, there was Lord Woolf. He really streamlined, and he brought about something called Woolf reforms that people who do civil litigation will know. And that really streamlined a lot of the backlog. Unfortunately, in Bangladesh, there wasn't any such conscious.
You don't have any Woolf.
We don't have any
we
Woolf.
Need Wolf.
No, we need a Lord Woolf in Bangladesh, yes. And unfortunately, that has been that. But it's very unfortunate that there is a backlog. But there is a system. I think we have to be very optimistic.
Yeah.
Bangladesh is just 40 plus years, and where it is now, it's an edge, and
it's very conveniently we say Bangladesh is 40 plus years, you see, but we have leapfrogged many stages, you see. We carry mobile phones in our pocket, and we never bother about that, you see. We have developed. We use computers. I mean,
absolutely,
high resolution computers. We use HD televisions, you see. But when it comes to something that we can conveniently ignore, or probably that is an excuse that only 45 years, 47 years. So we are using the same technology that other countries are using. You see, is it a mindset or just technology?
Well, it's
or our inefficiency.
No, I wouldn't say that. I think there is something called maturity. The people need to be mature about certain steps, and where the legal system is at the moment. It is just there, but of course it needs a lot of improvement. In comparison, because we understand things in comparison. When we compare because we are connected with Bangladesh and UK, we automatically compare Bangladesh with the UK, whereas the people who live here are very different from the people who live there.
True, the system is different.
The system is different, the culture is different, and lots of things will just not work. So in terms of the maturity, I think Bangladeshi people have not yet come to that stage where they, as of necessity, demand such an advanced system, because people find ways to bend the rules.
Yeah.
And
if they can bend, they will. If
they can bend, they will. And hopefully, in the coming years, we'll see better times.
This backlog of thousands and thousands of cases, see, does it help the lawyers? I know that for sure does not help the poor chap who is
there are actually lots of jokes about it, and I'll share one. There was a newly qualified lawyer. He came very enthusiastic. This is of course a joke. They came very enthusiastically one day at home, and he said, Dad, I finished this case today, I got a relief. And Dad was like, he put his hand on his head. You finished the case today? I just sent you to court once. I've been running this case for 30 years, and you finished it today. So there is a source of income. There is an ulterior motive to run cases, but the thing is, of course, it's not good for the clients. It doesn't. The sooner the justice delayed is justice denied. And us being in UK, we are very conscious of the fact that UK clients demand and expect results, at least to have a very fluid relationship and a communication that, okay, it's taking time. Why is it taking time?
Yep, yep.
And most of the time I just do that, explain to them. I still have to deal with the case taking time, but at least I'm able to explain to them in person, in the same time zone, that why it is taking time. And if they mail me or call me, at least I'm there to respond to their concern. So it does help the lawyers to an extent, but of course, I mean, I cannot say whether it's intentional or it is just the system. But even if it's not, civil litigations are a very lengthy process.
Well, asking you the question is like asking a horse whether you like grass or not.
Well, you see, lawyers have a lot of different kind of work. There's advisory work, there is the litigation work, there's drafting work, and there's the research work. And people who are not lawyers really underestimate how much work lawyers have to do. because it looks very simple from a non-legal perspective.
No, I don't think it looks simple. Because looking at the huge voluminous books that you carry, see, I can understand it's not simple.
And it is actually, and that goes back to the question why I came into law. It is a very, it gives you a different take on human nature, and that fascinates me every time. And all my clients, they are such unique individuals with a unique set of problems, and I think to be able to come into their shoes and them allowing me to take their position and help them, it's a privilege.
Yes,
it's an absolute privilege.
You have to feel like them, and then you have to fight for them.
Yes, yes, absolutely.
Do you practice at Supreme Court?
At the High Court Division. I'm High Court Division enrolled, not Supreme Court Appellate Division enrolled.
What is the purpose of this? I mean, again, I will go back to the same thing, that if we have so many courts, then all the cases should have been dealt with. See, we have District Court, Magistrate Court, and then the High Court, and then the Supreme Court.
The High Court is the appellate court. So the lower courts, they will be actually doing the trial. But if one party loses, of course, they would want to appeal against the decision. And the High Court is the appellate forum, just like here.
Is it easy, or rather very easy, to get the dates changed on this or that pretext?
I think you're referring to adjournments, taking dates. Of course, you have to take a reason. The judge, you have to persuade the judge that there is a pressing reason for an adjournment being asked for. If it is just that you didn't show up, or you have to present a reason. So depends on what your luck really, which judge is on the bench today, and is he in a good mood or she in a good mood. So if you have a good reason and you have persuaded them, then you will get the dates changed or an adjournment. But it's not always very easy, no.
Just tell me, I mean, I have heard so many stories about so many famous lawyers who can twist the law in favor of this and that. You see, the law is the same, isn't it? For the
law is...
But the two lawyers who are fighting in the courtroom, see, they can twist it in favor of this or that client.
Well, I will take... I will maybe respect.
Sorry, you may not like the word twist,
yes,
see, but
I have.
but use the law.
Well, the law is subject to interpretation, and our ethic is you represent a client, you look out for their best interest. So you interpret. You are entitled to interpret the law, or help make a case where you're interpreting the law in a certain way. It helps your client. A lawyer by themselves don't do it. Of course, there are cases where the judges have given a certain angle on a particular law, and our job as lawyers would be to highlight those particular decisions.
And sometimes you refer to the previous case of Johnson and the state.
Absolutely. So this is called precedent. So we refer to previous cases where there were similar decisions, and this is the same in the UK and Bangladesh, actually, the doctrine of binding precedent. And this is very good because it allows the judge to see all the different perspectives. I see the UK common law, which is very unique from the continental or the European legal system, is it allows a debate. It allows a it allows a challenging intellectual exercise, and it allows for deductions and conclusions and precedents, and it brings in, and within that is meshed a lot of fairness and a lot of analyses, and that's has to be good for the client, because
is it a match between the judge and the prosecutor and the client of the lawyer of the other?
Well, sometimes you will get a difficult judge and you have to make your case, and that is the work of an advocate, that they have to be persuasive and they have to highlight all the strengths of a case. It might look very weak at the beginning, but only when you have heard them, their side of the story, you have seen the cases which these lawyers are bringing forth, can you understand the strength of a case. In one particular case, in an employment matter, which if I allow me to say, we lost that case, but we won on cost. So even though we lost the case, we won on cost because the judge has found there were many materials to be decided, which couldn't have decided otherwise.
Okay, again we are at that juncture that we have to take a break. Okay, viewers. break, and then when we come back, we will again go back to the court of law. Thank you.